just try to refer to them, if you have to refer to a child by initial or by just referring to a child. And also, we are being recorded as on, and actually filmed for YouTube, and the arguments will be available on YouTube, so I'm just cautioning everybody about that, so stay behind the podium and keep your voice up. I don't think we'll have to worry here, I think it's being magnified all over the place. Go ahead.
Thank you, Your Honor. May I please the court counsel? My name is Frank Maskey. I'm here on behalf of the appellants, Summit County Children's Services, Darlene Bay, John Saros, Dana Clapper, and Dawn Averill. Counsel with me here today also is Ms. Katrina Pappas. I would like to reserve 4 minutes for rebuttal, Your Honor.
Thank you.
As the court is aware, this case involves 2 minor children who were in foster care associated with Summit County Children's Services Board, and summary judgment was filed on behalf of all my clients as it related to the issue of immunity. I'd like to first address the immunity issue as it relates to Summit County Children's Services. As this court has already decided in a prior decision that Mr. and Ms. Whitaker's firm and my firm was involved in, back in 2006, Grimm versus Summit County Children's Services Board, the court, as it relates to the agency itself, has a 3-tier analysis that has to be undertaken pursuant to 274402. In that 3-tier analysis, the first tier is that Summit County Children's Services is a political subdivision. That is not contested in this case. That is admitted. This court has found that in prior decisions. The second tier then is that Summit County Children's Services enjoys immunity, but for acts that may come within the 5 exceptions to 274402. That is the second analysis, or the second tier. Those 5 exceptions involve things such as operation of motor vehicles, performance of a proprietary function, which this court has decided, and I think all parties agree, the operation of a children's agency is a governmental versus a proprietary function. Keeping roads in repair, negligent acts that occur because of the condition of buildings, and the only potential exception that the appellees may try to argue, and that is 5, and that is that there is civil liability imposed by a statute. The other 4 exceptions that I just referenced have no bearing whatsoever to any of the claims in this case. Summit County Children's Services enjoys immunity. That issue regarding liability imposed by a statute has been decided by this court and has been decided by the Ohio Supreme Court. There is no specific statutory duty to investigate a claim of child abuse. Therefore, since none of the 5 exceptions apply in this case to Summit County Children's Services, the agency then should have been entitled to summary judgment, and we would ask that this court, since this is a de novo appeal, that this court not only reverse the trial court, but issue judgment in favor of Summit County Children's Services, because they do have immunity for the claims in this case.
Okay, you say that there's no statutory authority to require them to investigate child abuse cases, correct?
There's no specific statutory duty to do that. That is correct.
Okay, but is there a statutory duty for them to investigate the foster families and the homes of the foster families?
There is not a specific statutory duty for that obligation. So this then, since the agency enjoys or has the immunity on the issue, we then turn our analysis to the individual defendants in this case. And the first one I'd like to reference is Mr. John Saros, who was the executive director at Children's Services Board at the time that the alleged abuse was occurring. And I would indicate that.
Just for a second, I'm sorry. But for clarification purposes, when you begin with you said the individual employees, but they're named individually as well as officially.
They are named individually, yes, Your Honor.
But are they named in their official capacity?
They are named in their capacity capacity, but the court or the courts have decided you can't circumvent immunity by trying to claim respondeat superior.
Well, I understand that, but I'm just asking what in the actual complaint. That's why I just want to make sure we're all.
Yes, in the complaint, Your Honor, I have to double check that, but I think they are named solely in their capacity as employees of Summit County Children's Services.
Thank you, I just want clarification.
The first employee I would like to reference again is Mr. Saros, who was the executive director during the period of time that is at issue in this case. I would challenge opposing counsel to cite to this court any reference to John Saros other than on pages, I think it's 114 to 116 of the deposition of the mother of C.H. She indicated she met Mr. Saros one time. It was at a meeting at CSB, and that meeting took place before she had any knowledge or any indication that her son allegedly was being abused. That is the only reference you will find anywhere to Mr. Saros in the record before this court. There was some attempt to submit a newspaper article from 2012 where there were statements allegedly made by Mr. Saros. The trial court has stricken that in an order of this court when it ruled upon the summary judgment motion. There were 4 items that the appellees attempted to utilize or use in support in opposition to the motion for summary judgment. That was the verdict forms from the trial of the perpetrator, the verdict, police report unrelated to the children in this case, and this newspaper article. Those 4 items have been stricken by the trial court, and we would argue should not be considered by this court. I would like to focus now on the remaining employees involved in this case. That would be Dana Clapper, who was involved in solely the care or overseeing the care of, I'll call him RQ. RQ's brother, and RQ's 2 sisters. Ms. Clapper was the social worker assigned to all 4 of them. She was assigned to them for the period of time between, I think it was January of 07 and approximately November of 08. You have the affidavit of her regarding the contact that she had with the children, with the family. You will see, and I understand that you have to look at the evidence in a light most favorable to the plaintiffs in the underlying case, but you will see, and it's unrebutted, Ms. Clapper had full access to RQ. The perpetrator in this case would allow Ms. Clapper to freely see him, meet with him outside of his presence, in his presence. The young boy would have weekend visits with his mother during the course that he was in foster care. You will see that Ms. Clapper took the child to doctor's appointments, school appointments, would have lunch with him, interacted with him on a regular basis, announced and unannounced visits. She will say at no time was it ever disclosed to her that the child was making any claim of any type of abuse. In fact, the child at the criminal trial, which the transcript you have, agreed that while he was in the care of his foster father, he never made any allegation of abuse. He also testified at deposition in this case that while he was in the care of the foster father, that he never made any claims to Ms. Clapper about any wrongdoing. In fact, his testimony was that at the time he was probably 5 or 6 years old, he didn't know what was appropriate or inappropriate.
What do you make disclosures to?
He had no time indicated that the foster father was touching him inappropriately, asking him to do inappropriate things. Ms. Clapper, in her affidavit and in the records of Summit County Children's Services, has indicated they at no time were notified of any potential wrongdoing.
But is that not disputed by the parents of the minor?
It is disputed, Your Honor, and in this case, the child himself said, I never said anything to the lady from CSB. He didn't know her name. He said it was the lady who had the blue van that I would get in the van with. That was Miss Clapper. So the child did not. The mother said that on 3 occasions, she thought something was wrong. And it was shortly before the child was released to full custody of the mother in November of 2008. It was a couple weeks before that. The child would have visits from Friday to Sunday. She said she, on one Friday, asked the child if something was wrong. The child indicated that. I go up to the bedroom of the foster father. She said she tried to call Miss Clapper on the phone that day, got a voicemail, talked to her on, I think, Monday of the following week, keeping in mind that after being told this, the mother, who has acknowledged she knew how to use the hotline at CSB to report any potential abuse whatsoever, never went that route. She did call Miss Clapper, and Miss Clapper, according to the mother, said that she would look into it. That is in dispute. The mother said that is the only time that she ever contacted CSB about her son. In the 2 subsequent weeks, during these weekend visits, she simply said to her son, how are you doing? How are things going? And he never really responded to her.
Counsel, you're into your rebuttal time.
Oh, I'm sorry.
No, you're fine. I just wanted you to answer.
Okay. So that is the extent of the contact with CSB as it relates to Dana Clapper and RQ. With respect to CH testified at the criminal trial. I never had I never reported to anyone at CSB that there were any problems.
Counsel, what does that really have to do with summary judgment motion that he testified to? I mean, I can see a trial that you can impeach him.
No, Your Honor, because the very issue, simply because there is a discrepancy in testimony, does not create a genuine issue of material fact as it relates to what the standard is here as to the individuals. And that is, there has to be evidence of malicious purpose, in bad faith, and in a reckless manner. And this court has decided, as a matter of law, in Grimm, that a directed verdict motion in favor of the individual, or a directed verdict rendered in favor of the individuals, was appropriate in a case where the social workers allegedly did not report abuse or should have further investigated. Again, negligence is not the standard. And somebody may say that what these licensed social workers did could rise to the level of negligence, but it does not rise to the level, and this court can determine as a matter of law that it is not recklessness. And again, in our brief, we cite both the Grimm case and another case. I know...
I agree with you, Alex, about just one more question, because you are in your rebuttal time. If you would agree that, just hypothetically, that the caseworker was informed and knew about the allegation of abuse, not investigating, not doing anything would be recklessness.
Your Honor, not in the situation in this case.
I didn't say that, so hypothetically.
Well, hypothetically, I think I need to know more. I need to know if, in fact, the mother or if the social worker has repeatedly been told by the children, this is great.
So you have to have a child tell a caseworker repeatedly?
No, not at all, Your Honor. It's what happens is, in this case, over time, several professionals have all had involvement with both of these children. No report of problems. The children report to the social worker repeatedly. Everything is fine. I love this foster home. As a matter of fact, will say in his deposition, and I can cite you to all the different versions, that he continually lied to the social worker, telling her that everything was fine throughout the course of the case, or the time that he was.
Counsel, I just wanted to indicate to you that you only have about 30 seconds left. Do you want to say that?
Okay, I will say that, Your Honor, thank you.
You may proceed. Thank you, Your Honor.
Good morning, Your Honors. Andrew Whitaker on behalf of the appellees. I'm here with my co-counsel, William Whitaker. I will just refer to them as mother and child, with a younger child and an older child, and if the court's all right with that, that's how I will refer to them as I go forward. Let's be perfectly clear. What happened here is that Summit County Children's Services placed these boys in the home of a predator. These boys were kept in the home of a predator after an allegation in 2008, unrelated to these two boys. And then these two boys were kept in this home after both of these boys' mothers went to the social worker and complained about their concerns. Now, we heard from Mr. Mascot, well, moms could have just called the hotline. Moms could have called the police. As this court knows from dealing with children's services, they are the only line these mothers have to their children. Everything must be run through their caseworker. And these women are always in total fear of not getting their children back. So to say that they should have disobeyed the rules and gone outside of the chain that they are told to again and again follow, contact your caseworker, ignores the power dynamic that exists there.
So you would refute the appellant's argument that there was no duty for them to investigate the child abuse?
I absolutely would refute that. The children are placed in the care of Summit County Children's Services. It is their statutory, it is their moral obligation to take care of those children. They are removed from a home because of danger. They assume custody to protect those children. When mother after mother come to them and say, this man who is their star foster father, but only wants boys of a certain age, come to them and says, there is sexual abuse happening. My child, who's 5, of course he can't identify good touch, bad touch, but he relates to mother information that causes mother great concern, and she immediately contacts the caseworker. I do believe there's an absolute duty for them to investigate that.
And you talked about the 2008 allegation.
Yes.
What is in our record regarding that allegation?
I believe that there's deposition testimony regarding that. I understand.
Deposition testimony of whom?
I believe it was the mothers. I understand the mothers of the children.
They are talking about an allegation against the foster parent?
I believe so, yes. But they learned about.
How would they know?
They learned about afterwards, after the children had been removed and Mr. Ball had been prosecuted. The mothers and the children were both part of the criminal trial.
After, okay.
Right, so they didn't learn about it until their children.
So it's in the record of the criminal trial?
It is definitely in the record of the criminal trial, which is a transcript that this court has before it. I do believe additionally it was a part of the deposition testimony. So the court.
So did you bring in any testimony in this case relative to this 2008 allegation that CCFD should have been aware of?
That the only testimony besides the deposition is the criminal trial, which the appellants attached to their reply brief.
Counsel, in regard to that, criminal trial, so you're saying it can be used, but yet at the same rate, you're arguing that the individual children, the child here did not, contradict himself or testify inconsistently.
Well, Your Honor, I'm not arguing that there is not some inconsistencies in the testimony of what at that point was a 6-year-old child and then years later testified. What we're arguing here is that the testimony of both the children and the children's mothers provides a genuine issue of material fact here, and that the trial court properly denied summary judgment on that. I agree with what the court indicated. Those are certainly issues for impeachment at trial, but they are irrelevant. Trial testimony of children who've been repeatedly subject to sexual abuse years prior to this deposition testimony does not create such a contradiction that their deposition testimony and the deposition testimony of the mothers cannot be relied upon. So what I'm saying here is that there is a genuine issue of material fact upon which the trial court relied. Again, the trial court had, while it wasn't in the original summary judgment motion, it was in the reply brief appellant's argument regarding the trial testimony. That transcript was in front of the trial court. The trial court still found genuine issues of material fact based on the deposition testimony. It specifically referred to the children's deposition testimony on page 3 of the opinion, as well as the mother's deposition testimony. That created a genuine issue of material fact. Questions about whether or not the children said it enough, or if they said it directly to the worker instead of the mother, or how many times they told the worker they're happy, it's okay, for fear of who knows what, are trial issues for impeachment, are trial issues of fact for a jury to address here. So I think that's an important distinction.
Counsel, the other question I have for you is, well, actually, I have two. You said 2008, you started your presentation, your argument for this, and you say we place children in the house of a sexual predator. You're not alleging that CSB knew before they placed the child, the children, in the house, that they knew about.
The older child was placed in the home of Mr. Ball in January of 2009. The younger child was placed in the home of January of 2007. So the younger child was placed prior to the other allegation. The older child was placed after.
Right, and I'm asking as to what CSB would have known at the time.
CSB was aware of that prior allegation. So they were
What is our record that shows that?
That is in the trial court testimony, the trial testimony of Mr. Ball.
The criminal trial.
The criminal trial, yes ma'am, yes ma'am.
I mean, can you summarize the nature of the allegation from 2008?
Sure, the allegation was, I believe it was a family member, reached out to Children's Services and indicated that there had been some conversation with the child in his care that some sexually inappropriate conduct occurred.
What family member?
Of
Of whom?
a child that was currently in Mr. Ball's care.
A different child.
A different child, unrelated to these two children.
And what do we have that links that knowledge by CSB?
Because the person that family member reached out to was Children's Services. And Children's Services was aware of it and referred it to the Akron Police Department.
So it was referred by CSB to the police department?
It was, yes.
Is that standard what they would do?
It is standard what they would do.
But we don't have that here.
That is in, they don't have that here at all.
So that the fact that they really don't have a duty to investigate, but they do have a duty to refer
There
it.
isn't
For
a,
investigation.
right, there isn't a statutory duty to investigate. They have, as mandatory reporters, a duty to refer it to the police department. They did not do that here. They failed in that statutory duty to report an allegation of abuse.
And that's all based upon the fact that they knew about this abuse.
Yes, the mothers and the children both provide testimony in their depositions that provides evidence that the individually identified defendants in this case were informed of the sexual abuse against the two children.
And the conflict is in that the CSB entire defendants had no, testified they had no knowledge.
Right, so there were
It's
affidavits.
a conflict.
Right, so there's affidavits attached to the appellant's motion for summary judgment, and in those affidavits, they claim that they were never told of these allegations till after the children had been. So that is the issue of material fact as it relates to these three defendants. I find it difficult to imagine how there's an issue as regard to if the children, in fact, had notified them, if the mothers had called them and said, my children are being sexually abused, how that does not rise to the level of reckless by not removing the children and not investigating.
Counsel, there you're getting into what my second question was, and that is in regard to CSB itself as a political subdivision.
Yes.
Your argument is how are they reliable? I mean, in other words, these 5 exceptions under 2744, are you saying in answer to Judge Rice's question that there's a specific statute?
In regards to CSB, the entity, I'm certainly well aware of the Grimm decision and the case law on that. We, in our opposition to the summary judgment, dealt with what we believe to be the constitutionality of that law. I understand the judge disagrees disagreed with that, and that would be an issue down the road potentially. But in terms of the entity itself does not have the statutory duty that I refer to as a mandatory reporter. That's about individual employees.
That's what I was wondering.
Yes.
Okay, I would clarify that.
Yes.
I thought you were arguing that they had duty as well.
No, the individual employees are the mandatory reporters, and the individual employees are the ones that were in fact notified of the sexual abuse. So,
But you sued them in official and individual capacity.
yes, you are, yes, you are. And while in the trial level, I don't believe appellants argued much about reckless. It was mostly the issue of disputed fact. They argued that these individual employees were told, therefore they're entitled to summary judgment. Before this court, they have relied more on the issue of that there's no evidence that these three employees were reckless. And again, I don't see how you make an argument that leaving children in the home of a predator who this court affirmed is 35-year conviction, how you leave children in a home where they've had repeated allegations of sexual abuse against those boys is not reckless. It is, I think it rises very easily to the level of malicious, wanton, and reckless conduct. It might be a different issue had Children's Services argued that their workers were in fact notified, but these are the reasons we chose not to do anything. That then might be an issue for summary judgment. That might be a legal issue upon which trial court or this court could opine about whether that conduct rose to the level of recklessness. But the summary judgment and their brief here relies on disputed issues of fact, whether or not these caseworkers were told about sexual abuse. And our brief points to, again and again, in the deposition testimony about the older child being raped and fondled by Mr. Ball. He gradually began telling his mother that he was sexually being abused. She immediately called two of the defendants about the sexual abuse of her son, and they accused them and her child of lying. Mr. Ball was their star foster father. The mother of the older child received a similar response. She called again and again and was told again Mr. Ball wouldn't do that. He's one of the best foster fathers that we have. But again and again, they were told that they were lying, that they were just trying to get their children home sooner, and that they were not going to remove the children because they did not believe the allegations of sexual abuse. I think that what we have here is a continued victimization of these gentlemen, these boys. These boys were brave enough to testify at a trial against their abuser. CSB now seeks to use a small portion of that testimony against them. Even during the deposition questioning of the older son, of the older child, while he's being questioned in deposition, that while he was being sexually abused, in an apparent attempt to indicate that there was no harm, well, your grades went up during that time, didn't they? I mean, these boys are brave. They came into court and they confronted their abuser, and they continue to be victimized. The Children's Services briefs to this court seem to defend Mr. Ball and refute the accusation of whether or not he in fact abused those children. And I think that this court has a clear answer, especially as it relates to these individual defendants. That the issue before the trial court was disputed facts. This is a quintessential jury issue. And the safety of these children, based upon these disputed facts, is something that should have gone to a jury. What CSB knew should have gone to a jury. And the trial court's ruling that summary judgment was not appropriate should be upheld by this court. Thank you.
Counsel, you only have 30 seconds.
The trial court did not address the issue of malicious purpose, bad faith, or recklessness. It simply found that there were discrepancies in the testimony. Intentional design to injure, dishonest purpose, conscious wrongdoing, complete failure to exercise any care whatsoever. That is the standard. I would request that the court please read the depositions of the four people, the affidavits, and I would ask that you find their conduct of the individuals did not rise to the level of conscious or malicious purpose or bad faith.
Thank you.
I would ask that you reverse the decision of the trial coordinator judging in favor of my client.
Oh, I'm sorry. Yes, I have a question.
You indicated you want to read the deposition testimony of the 4 individuals.
Yes,
Who would that be?
it would be the 2 children and the 2 mothers. They will set forth what the evidence most favorable to the appellees would be. In this case, there are no experts, no standard for licensed social workers ever presented to this court. And I would also ask that you review the affidavits of the...
Why is the fact that there's no experts involved here? What's relevant?
Because, Your Honor, I think it goes to what is the standard of a licensed social worker based upon the information that he or she has at a given time. You were told about a sexual predator who's in jail for 35 years. That happened in 2012, 2 years after anything here. You were told about some report in 2008. That is not before this court.
All right, thank you, Counsel.
Thank you very much.